So we're going to do a just kind of a deep dive into basic trust. And what I'm going to do is I'm going to start with just kind of the basis for even that, where it comes from, and I'm just going to lead up to the most simple definition we can do, and then I'm going to build off of that. We're going to start with the question, what is trust? And before we actually go into the definition of that, we're going to talk just real quick about where it comes from. Trust is part of the natural law. Natural law, in case you aren't familiar with that, is what it says it is. It's the natural order of things. So, natural law is defined by nature and the rules of nature. It is undeniable. One thing that sets it apart from the types of laws and codes and statutes and things that we're used to, man's law, is that natural law never changes. It's the same today as it was yesterday. It will be the same tomorrow, same as it always has been, as it always ever will be, unless God changes his mind, because natural law is widely regarded as God's law. And I believe very firmly that that's what it is. Man's definition of trust, pulled from the dictionary. Trust is a firm belief in the integrity, ability, or character of a person or thing, which means confidence or reliance. So that's the American Heritage Dictionary. Another common definition that you'll see all over the place is trust is confidence in someone or something. And I'm going to reword that and put it in my own words. I do like to think in terms of spirituality. To me, trust is simply faith, and it's faith in a promise. When I say faith in a promise, I'm saying everything that has been said in the definitions implies the existence of a promise. Because if you have trust, you're trusting in something. You're usually trusting in something that you intend to receive. You know, if you put your trust or your faith in someone, there's usually an expectation of something. So it's faith in a promise, and the promise implies a gift or a benefit. I would say that that is going to be found to be true 100% of the time when the word trust is thrown into a conversation. One other set of characteristics that I just want to run through real quick is that trust is a type of a contract that does not go against what we say about it being natural law. Contract is not necessarily a legal document. There are contracts in nature. Believe it or not, contracts have their root in nature as well, in the natural law. All trusts are contracts. So trust is a type of contract. So all trusts you see are contracts. The flip is not always true. Not all contracts are trusts. That is important to realize. And just like a contract, a trust can be expressed or implied. What that means is it can be expressed in words, either spoken or written, or it can be implied by actions and circumstance. We can imply them in nature all over the place. This is already a long presentation, so I won't get too deep into that type of thing, but just to say that it's there. And then the last thing I want to say that is there, which is equity. You can't talk about trust without equity. I'm not going to talk about it because that's a whole other, at least an hour-long conversation. But equity is there for when trust fails. We're on an imperfect planet in an imperfect world with imperfect people. Trust is not perfect. It will fail, it will break, and equity is what's required to make it whole again. Equity means equality. It means justice. It means whole. So I'm going to sum this up into a simple definition that is widely accepted around the world by people big and small. And that is trust is something held by one party for the benefit of another. And that definition is going to work no matter what context you put that word trust into. So I'm going to go through simple trust, basic, simple, vanilla trust. I'm going to start with three statements, and I'm going to briefly say what they mean, and then I'm going to dig into hopefully helping you to understand what they mean, because it might sound like word salad to some if you've never heard this language before, but I'm going to try real hard to say it in a comprehensible way, and then show you what it means. So hopefully by the end of this presentation, you'll understand some of the language. So the first statement is a trust splits the root title of an asset into legal and equitable titles. This arrangement is called usufruct. The opposite of that, if you merge a split title back into a allodial root, that collapses a trust. Okay, so you split the title, you create trust. You merge a split title, you dissolve a trust, you collapse it. A trust also collapses when the beneficial right by nature of a living man claims the beneficial right of a legal fiction by characteristic over the same subject matter. A living man has a higher claim than a legal fiction. So a legal man can collapse a trust that is only based in legal fictions. So all a title is a claim. It's proof of a claim. Actually, the title is proof of claim. So when we say allodial title, what we're talking about is root title, and that means the title is whole. That means it's in the hands of one. The same person that holds legal title also holds beneficial title. They're all in the same package. That just means I'm responsible for it, I own it, and I get to use it and keep it for myself. It's mine, only mine. That's allodial. It means whole. A good example, a simple example of allodial title, you go into Walmart and buy a TV. And on your way out the door, the greeter says, hey, can I see your receipt? And me being the peaceable guy that I am, knowing I don't have to show her that, I show it to her anyway because I don't want a conflict. So when I pull that receipt and I show it, what I'm actually showing her is a allodial title to that television. I've bought it, I've paid for it, it's mine. Here's my evidence, here's my title, here's my proof of claim that it's mine. She says thank you, and I walk out the door. That's allodial. Now, if I get that TV home and I decide that, I bought this for my kid, I'm going to put it in my kid's room. So I'm going to take it in there, I'm going to set it up and, tell my kid, hey, this is your TV now, you get to use it. But I expect it to be turned off by 10 p.m. every night. And I expect you to honor the parental controls. I don't want you to try to get around those. And I expect you to still do your homework and do your chores and keep your room clean. And if I catch you watching TV when you're supposed to be doing other things, I'm going to take it away. If I catch you watching after 10, you're going to lose it. Matter of fact, get a dust rag out every now and then and wipe it off. I'm giving rules, these duties, obligations, and parameters around the benefit of using my property. I'm assuming like a controlling interest in the thing in order to protect it for the kid and protect the kid from the property. So there are rules for that in trust, and that is called divided split title or usufruct. So now when we do that, when we hold a piece of property, a gift that we control on behalf of another, and we create that split title usufruct, what we do is we create three different positions. The first one I've split apart. It's the same office, the grantor settler's office. This can be two different people. This can be the same person. It depends on the circumstances of the situation, but I'm going to break them apart just for definitions here. The grantor is the creator of the trust. The settlor furnishes consideration and exchanges property into the trust. So the grantor settlor is the one that is the office that creates the trust, writes the rules, puts the property in, and is the capital interest of the whole thing. They have the highest interest in the whole thing. They are the ones that create it from nothing. There's another seat that is created in this called trustee. So this is the one that holds legal title to all the trust assets and carries out the conditions of the trust contract. We call that contract an indenture. It's called a trust indenture. There's a reason for that. Hopefully you'll see it by the end. So the trustee also holds all the liability, suretyship for the trust. They are responsible for the property. They're responsible for the whole trust. They are the ones that have to answer for things. And then that last seat is beneficiary. Beneficiary holds equitable title to trust assets. Equitable title is also called beneficial title, same thing. That just means that the beneficiary gets use and possession of the property. And that comes with certain duties and obligations, just like the TV. The kid gets use and possession of it. I'm dad. It's my property. I control it. I say when you can and can't have it. If you abuse it, I'm taking it away. There are rules to trust. There are duties and obligations. There are things that beneficiaries have to do in order to protect their own benefits and that they are expected to do. So trust has a law form. The creator decides what that law form is going to be within the trust. In trust, you have this cool thing of being able to create private law and even name like another law form that is like a basis of law, but then you get to write, your own laws, your own private laws, bylaws, and things like that. So those are the three offices. Now, I'm a visual learner and I like to draw pictures. I'm going to draw a picture of trust for you. There are three offices. The easiest way to represent that in the simplest form is with a very simple triangle. We're going to let each corner of the triangle point to a different office of a trust. And again, this is just basic trust. So at the most basic level, this is going to apply to most forms of trust. So the first office we're going to stick in is the grantor settler's office. As I mentioned, the grantor settler holds the allodial title. They hold the root title. That gives them capital interest. And by capital interest, I don't mean money and finance. I mean capital as in the head interest, the highest interest, the most important interest, kind of like the capital of a state or the capital of a nation. This is the capital interest on the trust. It's the most important interest and actually determines and defines what everyone else's interest is through the trust indenture and the law forms and all of that are created. Some other capacities, names, titles, whatever you want to call it, words that you might hear that you would associate with the grantor settler's office would be creator, executor, payor, franchisor, exchanger, or trustor. Not to be confused with the trustee, the grantor is the trustor. So the grantor settler, the first thing that happens is they'll take a piece of property and put it into trust. And when that property goes into trust, it's called corpus. A corpus is the initial gift, and then the corpus generates res. Both of those really just mean property. All corpus is res, but not all res is corpus. Corpus is the initial property. Res is everything else. So if the initial corpus were money and you were to take that money and buy a house for the trust and a car for the trust and insurance policies and all of that property becomes trust res. Not really important. I show that language so that if you see it elsewhere in your study of trust, that you understand what it's talking about. Corpus and res just means trust property. And when that property is put into trust, like we said, it splits. That allodial title is no longer an allodial title. It is now split into two. And when this title is split into two, it creates a whole new jurisdiction, a private jurisdiction. And of course, on the other side of the fence, you have the public. On the private side is where the equitable title, also called the beneficial title, exists. On the public side is the legal title. Equitable title goes to the beneficiaries. Legal title goes to the fiduciaries or the trustees. This public world is the world of legal stuff. This is where you're going to find the UCC and the United States Code and the Code of Virginia and the CFRs and all these bodies of man-made laws and legal fictions. You're going to find the corporations. You're going to find all the entities. You're going to find all that stuff out in public. That's the legal world, the world of merchant law and public commerce. Over on the private side, where the beneficiaries are, is the lawful side of things. That's where you're going to find things like private law and common law, equity and chancery, stuff like that. In this picture, if you see this thick purple line right here, we can call this the veil of trust. This is the veil that stands between the public and the private. If trust is done correctly, the public cannot see through this veil. The private can see out, but the public can't see in. If the public crosses over this veil, it's a breach. Same thing on the other side. If the private crosses over in the wrong way, of course, the private side is allowed to come out into the public. But if the private side drags something from the private out into the public, that is also a breach of trust. And so that veil is where breaches occur. That's also where a piercing occurs. So sometimes the public can actually pierce this veil without breaching it. They might find a weakness and go, hey, what's that? And pull a string, and then the trust spits all of its private guts out into the public. That happens, and a trust will fail like that. But by and large, the public is supposed to be kept out. The private is supposed to be kept in. The only one that can move between the two is the trustee. The trustee cannot move over here and claim benefits, but the trustee can absolutely see through the veil and communicate with the beneficiaries. And the trustee probably knows more about the private side than even the beneficiaries do. Hopefully, the trustee does. And then one last point is the trustee and beneficiary, those seats can never be occupied by the same person at the same time. If you have a beneficiary in a trust, they cannot be a trustee. If you have a trustee in a trust, they cannot have the same benefits as the folks on the private side. The trustee is compensated in a different way. The beneficiaries get benefits, the trustee gets compensation. It has to stay separate. The trustee is uninterested in the benefits, and they're given reasons to not have interest. The capital interest is with the grantor. We look at the beneficiary, their interest is defined for them. The beneficiary, believe it or not, has a beneficial interest. They're in it for what they can get out of it. They're there to receive benefits. List of other things you might hear a beneficiary called. And this first one is special because it aligns with one of the maxims of equity, which says equity regards the beneficiary as the true owner. So the beneficiary is actually the owner of the property in the eyes of law. You ever heard the saying, possession is 9/10 of the law? That's referring to a beneficial owner. Some other things you might hear them being called is a member or a citizen, holder, complainant, user, operator. All those things kind of pretty much mean the same thing. They're the ones receiving the property. They're holding it. They're using it. They're enjoying it. It's for their pleasure. And they're not responsible for it. If something happens to it, it's on the trustee for the most part. And all of that comes with duties and obligations, whatever is laid out in the trust that the beneficiaries have to do in order to receive the benefits that have been placed in trust. So on the other side of that, on the public side, where the trustee is, the trustee's interest is a controlling interest. So the trustee does not get any benefit from the property, from the trust corpus, the trust res, the trust property. What the trustee does is control it for the sake of the beneficiary. So where you might see a beneficiary as an owner, the trustee manages ownership for the owner. The trustee manages membership for a member, manages citizenship for a citizen. These are the controlling side. These ships are the fiduciary roles. Trustee is also called a grantee. So you got the grantor up here that gives and the grantee down here that receives and then distributes to the beneficiaries. Trustee is a defendant. When it comes time for court, if a beneficiary or something in the trust there's a dispute somewhere that involves another entity outside of the private realm of the trust itself. It is the trustee who goes to court as defendant, not a beneficiary. Beneficiaries have no business in court. Okay, not when dealing with trust property and matters of private trust. That all stays in the public. That's the trustee's job. It's the trustee's job to either be a lawyer or hire a lawyer. You don't have to be a lawyer to be a trustee, but go to court, it's a good idea to hire one. They're the ones that do that. So trustee holds suretyship. Other names would be employee, franchisee, payee. So your grantor, again, that relationship of grantor-grantee. You also have this relationship of payor-payee, trustor, trustee. These two offices are very tightly interwoven. All three of them are very tightly interwoven, but you can see there's relationships between the grantor's office and the trustee's office. And then there's one other overlay I like to put over this. It helps me keep it all in my head and draw a picture in my mind and put things in the place that makes the most sense to me. I like to call this private area over here, this private jurisdiction, the law of the land. The grantor's office, the law of the air. And the trustee's office, the law of the sea or the law of the water. And I think it's really cool that that lines up to LAW, law for land, air, and water. Worth noting that if you look over here on the trustee side, you'll see lots of ships floating around at sea. The ships belong in the water. So ownership, membership, citizenship, suretyship, all that stuff belongs in the water. You call yourself any of those things, you're sitting in the wrong seat. And those words can get you in trouble in certain situations if you're supposed to be sitting over here. Important to know. Is a very important piece of trust, actually. So you're now looking at basically a picture of trust. We built a trust just by throwing property in it and splitting it and dividing out jurisdictions. If we wanted to take that property back out and return it to the grantor because there's something in the trust that says if the beneficiaries don't follow the rules or something happens, some event, whatever event is in the trust, that the corpus is returned to the grantor, then the trust is done. It's over. It's dead. It collapses. And then the other thing is, and this is important to know, you don't have to have living, breathing people in these seats. You can actually build a trust with three entities here. And what this last paragraph is talking about is if there's an entity, a legal fiction sitting in this beneficiary seat, and a living man comes along and has a valid claim to the corpus, the trust is over. The man gets the corpus and a new trust is formed, depending on circumstance, depending on what that corpus is and what kind of title the living man receives. So I'm going to go over a couple of examples because it's not only important to know what trust is, but it's really important to be able to identify it because it happens all around us. Like I said in the beginning, it doesn't necessarily have to be expressed in words. Trust is implied in nature, and it's implied in social interactions. It's implied in all kinds of stuff. I can guarantee you it's right in your face, right under your nose, right now. And I'll prove it. This presentation fits the definition of trust. I created it, I settled it, I've granted it to you, and I'm currently executing it. I have named myself as the person responsible to distribute it to you, to administer it to you. And if you're sitting here watching it and you're accepting it, then you have received a benefit of knowledge. You don't have to accept it. You don't have to believe it. Trust does work like that. You can reject it and pretend like you never saw it, or you could go, wow, this makes a lot of sense to me. I'm going to start applying it in life and I'm going to learn. And with that, I'll say you've got a lot of duties and obligations that come with that because I did not get this knowledge on my own. I got this from another, who got it from another, who got it from another, all the way up to what I just told you was the source. This is God's law. This is natural law. And I will tell you, trust is the mechanism of control in the modern world and the ancient world and probably the future world. It is the mechanism of control that's used to subjugate humanity. So you can use it for good, you can use it for bad. You start to understand it and you misuse it, That's between you and God. I wash my hands of that. But there are definitely duties and obligations that come with this gift here. So that's an implied trust. Just a simple example, right in your face, right on your nose, implied trust. We'll look at a very popular example of express trust, the U.S. Constitution. Grantors says it right at the top of the document. We, the people of the United States, do ordain and establish, blah, 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 blah. We're the grantors. What are we granting? We're granting the rights that we received from God. We had already made a claim to those rights. The Declaration of Independence, the Articles of Confederation clearly name God as the source of those rights. So we take our rights in the Constitution and we place them in trust. And then what did we do? We wrote this big old long trust indenture that built this whole public-private thing. We elected officials and set them off as trustees, created a whole succession through elections. So we're guaranteed officials as long as the trust is alive. And we named ourselves, we the people, as the beneficiaries. So we took our rights and we did place them in trust to be delegated, distributed, managed for us, and basically handed back to us as privileges and benefits. I hate to say that as much as the next person, but it is true. We did, as a society, do that. Not altogether bad, but it's not turning out too great either. Could have been a cool situation if we were running it right and they were running it right, but I'll leave it up to you to decide whether it's good today or not, or whether it can be salvaged. I hope it can, because it could actually be beneficial. But I think right now we're missing some equity in this equation, and our rights, privileges, benefits are protected in the constitutional trust and distributed back down to us, managed by our elected servants. It's called an indenture for a reason. Our elected officials are indentured servants. Very, very important. I'm going to show another one, another example. This one is a little more complex, but again, I've simplified it, probably oversimplified it. But let's take a look at what's called nested trust or trust web. So let's take a look at the U.S. citizenship, that 14th Amendment that we all know and love so much, right? So this is a nested trust. Grantor, settler, creator, executor, that's all the U.S. Department of State. U.S. citizenship is really for immigration. It was never really supposed to be applied to American nationals. We won't get into that, but we'll just show what is, which is, okay, so the Department of State is the grantor settler. They've also named themselves as the trustee. They have placed a gift of U.S. citizenship into trust. This picture of a trust, this whole thing we're looking at, would be named Doe John H. So they would name themselves as trustee and then name John Henry Doe as beneficiary. Now, if you're not new to this and you actually have a keen eye, you might notice that John Henry Doe looks a little bit like an entity, and that's because it is. Like I said, you don't have to have flesh and blood sitting in any of the chairs here. You can put entities in. John Henry Doe, in this case, is actually what's called a sole corporation. And a sole corporation is just another type of trust. So let's represent that trust here. This is what a nested trust looks like, or a trust web. It looks like a thing, but it's actually another. So we can expand it out and we can see that the living man, John Doe, is actually down here as a beneficiary of the John Henry Doe Trust. The U.S. Department of State drops down here. It gets named as trustee. And then, you know, if John Doe is a minor child, then mom and dad are listed as trustees as well. And this is where I say I oversimplify, because mom and dad right here is not really mom and dad. This is another trust web. This is a married couple. So you've got entities married to entities and people married to people and the state all up in everybody's business. This is a very elaborate trust web, nested and nested again, and probably nested 3 or 4 more times. That's what it looks like. And what this creates is this thing called pass-through. Department of State grants the citizenship into this big trust, names John Henry Doe as beneficiary. John Henry Doe is a U.S. citizen. So what does John Henry Doe do with his right? With not his, it's not a him, it's an it. What does John Henry Doe do with its rights that it can't even use because it's not even a real thing? Is it sticks them in trust and hands them down to a beneficiary. So it's not the citizenship that gets passed down, it's the benefits of the citizenship that gets passed down. So remember, the trustee is managing citizenship for a citizen. And down here, it's a little bit of a different deal. Down here, we're just managing benefits of a trust. And those benefits are making it down through pass-through. This is one type of pass-through. There are many ways to pass through trust, but that's what one of them looks like. If you have a really trained eye and you were really paying attention, you might be writing down the question right now. Wait a minute, is John Doe a U.S. citizen or no? And the answer is no. John Doe is not a U.S. citizen. He never was, never will be. He is a beneficiary of one. John Doe is not always the smartest guy in the world. Sometimes he makes mistakes, and he does this thing. He gets confused where he thinks that he's this thing up here. It's a real easy mistake to make. We see that name written on our driver's license with a picture of us. We see it on Social Security card. We see it on every document that comes our way. That thing is actually a trust. It's actually an entity. We're sitting way down here under it. But John Doe, he gets confused every now and then. He comes up here and he starts acting like he is the trust. And this causes a problem for John because when he does this, this department over here, this office of trustee, it breaks. They can't operate it anymore. There's something broken. So John gets, a traffic ticket or, a tax bill or, criminal charge or whatever it is John ends up in court for, and he'll make this really, really bad mistake of stepping over here and saying, yes, Your Honor, I'm John Henry Doe, the defendant. And he's going to find himself in a lot of trouble and a lot of hardship over there because one thing that happens when John Doe moves up here and over here, he's done this really wild thing of separating himself from his rights. And this is why when you go into court and you try to say something like, I have a right to this, or a constitutional right to that, or this amendment right to that, the judge will look at you and tell you you're full of it, that there is no constitution in the courtroom and you have no rights. And he's absolutely right because you separated yourself from those rights and you have no access to them. And everything is upside down in the courtroom, and all they can do is treat you like an incompetent minor child who has no idea how to manage their own affairs. So they bring out that lovely parens patriae doctrine and call you a ward of the state and an enemy of the state and all kinds of stuff and just manage your trust for you. And they say, well, if you want to sit in a trustee seat, we'll sit in a beneficiary seat and let's play. And we really can't blame them because we do it to ourselves when we do that. More than an example, kind of going off into a little bit about citizenship there. But that's what it is.